Buenas and Hafa colleagues. Welcome back to session. We are in second reading. We are now on resolution number 56-36, and I recognize Vice Speaker Tina Muñoz-Barnes.
Situs Maasi, Madam Speaker, and Manana Situs to you and to our colleagues. Madam Speaker, if I may, I'd like to move resolution number 56-36 COR as amended to the third reading, and if I could speak on it, Madam Speaker.
Please proceed.
Situs Maasi Talo. Hafa and good morning, colleagues. I have introduced resolution 56-36 in support of resolution 279, a bipartisan congressional resolution introduced by Chairman Grijalva and co-sponsored by Vice Chairman Khalili Sablan and our Congressman Michael San-Nicolas. The Insular Cases are a series of Supreme Court cases in which the court ruled on matters as diverse as tariffs, double jeopardy, and the very meaning of United States citizenship, as it applied to the inhabitants of unincorporated territories. These decisions were largely informed by preconceived racist views, and the court decided that the persons of some territories were less equal than those of other territories. Based on the testimony we received, everyone, governmental stakeholders, legal experts, and community advocates alike, agreed that the Insular Cases are rooted in racist, undemocratic ideals, which goes against the ideals of this nation and something that we must repeal. If any of you want to see some of the Supreme Court cases for yourself, I have gone through these cases and highlighted the racist sentiments, and you are more than welcome to read it for yourself. I also had the opportunity, Madam Speaker, to hear from the nationally recognized legal scholars in the field who rightfully indicated that while Congress is taking a step by calling the Insular Cases racist, they must also exercise their plenary powers and begin a binding political status reconciliation process tailored to each territory. Madam Speaker, I want to say, as a granddaughter of Colonel Juan Muñoz, whom Fort Juan Muñoz is named after, the wife of a proud Air Force veteran, the mother of an active duty Air Guardsman, the mother-in-law of an Air Force vet, and now a grandmother-in-law of a deployed soldier, the fact that we are still treated as less than equals does not sit well with me. I know that some have painted me as un-American, but I've stated on the record countless times, and even in my testimony submitted to the United States Congress, that while I personally wish for a closer relationship with the United States, ultimately, it is up to the people of Guam to decide what is best for our children and our children's children, not me alone. Given that the Insular Cases impact the people of Guam, it is imperative that the people of Guam express their sentiments on actions taken by Congress. This resolution supports the efforts of Chairman Grijalva and further supports our shared goal of parity for Americans in the territories. To those who want to paint this resolution as being un-American, I ask, what is more American than fighting for our unalienable rights? Rights my family fought to protect and families throughout this island. In fact, our predecessors in the 30th Guam Legislature passed not one, not two, but 5 resolutions calling for the protection of our indigenous culture and demanding the U.S. military address our grievances. These resolutions received bipartisan support and were even co-sponsored by some of my Republican colleagues here today, Madam Speaker, who are here with me today. To those who remain ignorant on the relationship between the United States and Guam on this very floor, over 70 years ago, our predecessors took a stand to fight for the injustices faced by the people of Guam and walked out as a protest against the United States naval government and to highlight their quest for a measure of self-government and the U.S. citizenship. It is because, Madam Speaker, of their courage, we got the Organic Act, and all of us here today have been given the sacred right to serve our people on this session floor. Lastly, Madam Speaker, I want to point out that supporting a congressional resolution does not bind the United States Supreme Court. And as I have stated time and time again on this floor, just as we cannot bind another branch of government when it comes to hiring whom they like, Congress cannot tell the courts what precedents to follow. Based on the testimony presented by legal experts, I had amended the resolution to incorporate their recommendations, as well as the recommendation of former Congressman Dr. Robert Underwood, to not only acknowledge that the Insular Cases are racist, that is the first step, but also to take a step further and urge Congress to use their plenary powers and engage in a binding political status reconciliation process, one that involves the people who will be governed and respective to the needs of each territory. Attached to the committee report, Madam Speaker, is a second supplement to the author's report, which is uploaded on our website. It is a summary of how symptomatic discrimination for our residents in the territory have impacted our people. The Committee on Natural Resources asked me to facilitate getting testimonies from Attorney Rodney Jacob. Many of you who are aware the injustice faced by his clients, the Schaller twins. Now we have another case, one of Mr. Frank Sonny Titano. I urge all of you to read the letter submitted so we all understand the real life impacts to our people of Guam. In the same file, you will find letters signed by over a dozen members of Congress asking the United States Department of Justice to end discrimination to territorial Americans when it comes to SSI. Just today, I was speaking with Mr. Richard Statton, the counsel to Representative Radewagen. And while Delegate Radewagen did not co-sponsor House Resolution 279, she did point out that it is not the courts but Congress who must act to rectify this injustice. This is why I amended my resolution to urge Congress to do just that, to do just this, Madam Speaker. Colleagues, as demonstrated in the latest supplement I had filed, there is a momentum in Congress to fix century-old injustice. We finally are making progress, from voting rights to access to federal programs, to taking our political status discussions to a new height. We have complained for centuries that our voices have not been heard. Many of my colleagues, both on my side and across the aisle, have signed on to countless resolutions dating back to the 30th Guam Legislature claiming our voices have not been heard. Today, we have a captive audience and the political will to move forward. We can't sit back and do nothing. In my decades of public service, Madam Speaker, I learned from former Governor Carl T.C. Gutierrez, the late Speaker Ben Pangilinan, former Speaker Judy Wampat, and more importantly, history, that if you find a problem, don't sit there and complain about it. Get up and fix it. You may be shot down, but that only teaches you to work even harder until you achieve your goal. For far too long, Madam Speaker, our people have been treated as second-class citizens. While we have one of the highest enlistment rates across the nation and proudly carry the flag, we are not afforded the same access to federal programs such as SSI and Medicaid. H.R. 279 is a major milestone in acknowledging the racism that has impacted the relationship between the United States and the territories. For once, we have the United States government recognizing the injustices imposed to the people of Guam. While we still have a long road ahead of us, Madam Speaker, after 76 years, we are finally taking the first step. While I'm grateful to Congress extended some flexibility for the use of COVID relief funds, I'm not going to beg to be heard, Madam Speaker. I'm here to fight for our people and our island. I hope each and every one of you can stand by my side today and help me on these efforts. Madam Speaker, as I mentioned to you earlier, I also have something that I received just it was delivered into my mailbox, my email, about 8 hours ago. And if I may, it's from the Insular Cases, Millions of Americans Denied Equal Protection Under the Law. The effect of the Insular Cases can be felt today. According to the Census Bureau in 2019, 65% of the people in American Samoa lived below the federal poverty line by 40%. But live below the federal poverty line. 40% of the people in Puerto Rico live below the poverty line. There are federal programs that are meant to uplift people. However, the territories do not have the same access and programs like SSI and Medicaid as the states. This is an anatomy distinction that must be rectified. And again, Madam Speaker, if I may, I'd like to also append this portion also to the committee report, if I may, because this is the most recent documentation that came in, and I would appreciate that. And again, if you'd like to work the motion first, and then
Yes. On the motion to append that document as a supplemental to the committee report, is there any objection? Seeing no objection, that motion carries. Please proceed.
Yeah. Thank you very much, Madam Speaker. Madam Speaker, I know I'm almost out of time, but I want to share with my colleagues that as we look at having almost 4 million people within the territories or jurisdiction of the United States, and we know that there are concerns regarding the disparities, not just concerns, but there has been a disparity between residents in the United States and those living in the territory. We must continue to have our voices heard. And this is one way of showing that step. Please, colleagues, I ask you, a lot of information is here, Madam Speaker. I ask my colleagues, please, let us stand together and help not just our island of Guam, but all our island territories that are a part of the United States jurisdiction. Wandunkulan Nasizuas Masi for giving me this opportunity to speak on Resolution 56-36 in support of H.R. 279. And again, ask my colleagues to please help me support the same. Sainamasi.
Sainamasi. On the resolution, Senator Blas, you're recognized, and then Senator.
Just a point of clarification, Madam Speaker, and maybe for the author. I noticed that this resolution is presented to the floor is different from the resolution that was introduced. So are we accepting the resolution as amended? Because it's substantially different from the resolution, so if that...
I apologize, Madam Speaker. I did ask for the motion as amended. in the committee. And
It was amended by the committee,
Yeah.
voted out of committee as amended by the author. Or
It was
voted
amended after.
By the author, sorry, not by a
It was amended after the
committee.
committee
Yes.
on rules, ma'am.
Sorry?
What we saw in committee and rules and what we're seeing today are two different. I just want to make sure that we're accepting the proper document. And the
Could you
motion is
repeat? The resolution as amended by the author is what was reported out by the author after the public hearing.
Yeah.
Is that right?
No, Madam
That's
Speaker.
correct.
The resolution as reported out after the public hearing is different from this. Ma'am, I'm just wanting to make sure we're addressing the proper
Madam
resolution.
Madam Speaker, if I may do address, just to be sure, notwithstanding, I'm seeing it on the Google Drive as amended, and I appreciate at least to make sure that we're talking on the right amendment. It is on the Google Drive. I can see it right here. But notwithstanding, then to accept that resolution as amended. Yeah, it was the version that was adopted in core. That's why it's up on the drive, but just for clarity's sake, just to be safe, I don't mind doing a motion again, just to accept it.
All right, on the motion to accept the as amended by the author version of the resolution number 56-36 COR. Is there any objection? Seeing no objection, that motion carries. And on the resolution as amended by the author, is there anyone who would like to be recognized to speak? Senator Blas, did you want to be recognized later? Okay, so Minority Leader Dueñas, you are recognized.
Sijus Masi, Madam Speaker. Good morning. I rise to not support Resolution 5636. And before I go into my rationale of why I don't support the resolution, I'd like to thank the author and the retiring speaker for recognizing the efforts, yes, of myself and a few other members on this floor, and others who even served as counsel and otherwise to the 30th and 31st legislatures and 32nd legislatures. That certainly this legislature, this august body, has always taken a keen interest in protecting the people of Guam, in protecting Guam's natural resources, in protecting our culture. As a matter of fact, it was so effective, Madam Speaker, that Build Up 1 became Build Up 2, and the 4 pillars were created. I say that because I've never seen a resolution until now by this body that has the potential of reversing at least the structure under which Guam, our beautiful island, Guam, our home, and other territories are at least recognized for their structure of government, are at least recognized while purported and otherwise racist language, nonetheless, the benefits of at least the basics that the Insular Cases provide. But this is not just my testimony, Madam Speaker. Let's go back to the public hearing for Resolution 5636. And let's share a comment from a legal scholar who actually hails from the CNMI. Professor Rose Cuizan Vilazar, Rutgers Law, was actually the first one to testify in the public hearing with regard to this resolution. Her testimony, Madam Speaker, was qualified testimony because the major concern that this esteemed attorney, professor of law at Rutgers, who hails from the CNMI, cautioned that supporting a resolution that's really not even a discussion in Congress, it's a discussion about the Supreme Court. The Supreme Court doesn't make laws. There can be an argument in the Supreme Court, but what do you want? You want to throw out the insular cases? Let's explore what that might do. For this esteemed professor of law, her concern was the current structure of land rights in the CNMI could be thrown out with the insular cases. That means our brothers and our sisters who have a very unique situation of fee simple property and otherwise could be in jeopardy of losing that very special benefit. Madam Speaker, I heard that there were some amendments provided in response to the good Dr. Underwood, our former congressman, based on his input from the esteemed gentleman. But I hearken back to the testimony, and if we watch once again that public hearing, it was more a discussion of what this resolution doesn't do. Where do we go from here? What are we asking for? If not the insular cases, what? Yes, my good colleague talked about self-determination. I'm all for it. On the record of this floor right now, Madam Speaker, I'm for statehood. I'm not going to equivocate. I'm going to declare it right here, right now, today. I've said it a million times in different forums. But this resolution is not about self-determination. This resolution is to support a resolution in Congress that has to be one of the weakest resolutions I've ever seen introduced, with 12 or so odd co-sponsors in a body of over 400 members. Normally, substantive resolutions on the floor of Congress are introduced by hundreds of members. Madam Speaker, let's explore the comments actually made, other comments by the good Congresswoman from American Samoa, Congresswoman Radewagen. I will be pulling it up here, Madam Speaker. These are her thoughts on House Resolution 279. Wholesale rejection of the insular cases may have unforeseen and undesirable implications on the future relationship between the territories, not just American Samoa, and the United States. The second point she makes, the resolution makes judgments on what precedents another independent branch of government can and can't base their decision on. This is a potential overstep of the balance of powers. Another point she makes, which I do agree with, one of the points my good colleague made earlier, the sponsor, rather than make moral judgments on the decisions of another branch of government, it would be prudent for Congress to use its powers as a legislative body to address the issues of the territories directly. Another comment by the good Congresswoman. Congress has better tools than a House resolution to, quote, make things right. Additional rights can be granted to the territorial residents either through constitutional amendment or by using its plenary power over the territories to rectify any perceived unfairness. This is the most effective way to actively distance ourselves from the racist rhetoric of the past while making real and substantial changes. The final comment in the good Congresswoman's points: one may disagree with the racist tones underlying the Insular Cases, but Congress should not abandon the wishes of the residents, now she speaks, of course, to her great territory, of American Samoa in the process. It is clear that our brothers and sisters of American Samoa view the Insular Cases currently as their vehicle for their own self-determination, for their own determination on being true citizens. I won't belabor the points, Madam Speaker, because actually I want to thank the Republican Party of Guam for putting out a statement on recommending substantive changes, even if we were going to address this resolution because of its implications when it reaches the floors of Congress. If you're going to say that you support jettisoning the Insular Cases, wiping them off the map, what then? Who has the power to determine our future? The same body that we just sent a resolution to saying wipe it out. I'm just going to mention the two precious things, I think, to the people of Guam that could be jettisoned with the Insular Cases. Our beloved Chamorro Land Trust. The ability to stand up that program, even though contested, has stood the test of time, and we recently just settled with the federal government in a landmark opportunity, and I thank Attorney Mike Phillips for that, to uphold the one thing that the people of Guam can hold on to a potential for future generations, a piece of land. Hope to God we get our infrastructure proposal that we put into our priorities, Madam Speaker, to get infrastructure in the Chamorro Land Trust property for affordable housing, and so those people can realize that dream of the leases that have been promised. That program is in jeopardy, Madam Speaker, and that's a fact. Our tax code currently, Madam Speaker, no jurisdiction in the United States of America has Section 30. As a matter of fact, I was offended because I watched the argument. But when one of my favorite governors, Joe Atta, was in Congress fighting for self-determination, there was a congressman who looked down his glasses on the tip of his nose and said, "Governor, you will not politic on my watch." Because the good governor was basically there to talk about self-determination. But the argument this congressman used was, I would love to have all the remittances of income tax by my residents stay in my state, not go to the Treasury of the United States of America. Unfortunately, it escapes me what state that belittling congressman conducted himself to one of my favorite governors. But it doesn't matter, it's immaterial. The fact of the matter is, the argument is that is a tax benefit to the people of Guam that balances this budget that we're going to argue about that we have to pass by the end of August, that for many years pays whatever unbalances and unbalanced books that we put forward sometimes, and even tax refunds that we don't have enough money in the bank for. Income tax, Section 30, getting the money of all the federal individuals who serve our military, who serve as contractors, who come to our island. I don't know about you, Madam Speaker, but I'm not prepared to go down a road when we ask for something, but don't ask for what the people of Guam want. You know, Madam Speaker, in closing, the vote on independence, statehood, free association, that's our responsibility. I am so tired of us beating up somebody else for something we should do. Let's do it. We raise millions of dollars every time we go out there and ask the people of Guam to vote for us. We can't raise $1 million to conduct our own vote? That you could have chamorros, as established by the registry, vote? I get to vote as a chamorro. Ihagao chamorro magahit. So if we want to talk about self-determination, let's do it. But I would never go to Washington, D.C. saying, get rid of the insular cases, they're racist, without going there and saying, and here's my list. Because Congress, the same people I'm sending this document to support a resolution that's probably not even going to hold up in the case that it's trying to support, I want to make sure I bring my list and say, oh, by the way, can you help us with this? SSI, I know. I listened to Ronnie Jacobs' testimony. I was hurting inside, Madam Speaker. But that gets taken care of in Congress. That doesn't get taken care of because the insular cases are gone. There is no magic wand if the insular cases are stripped from the records of the books. There's nothing that says right on Guam you are now a full-fledged beneficiary of all federal programs that exist throughout the 50 states. Only a law passed in Congress says that. So, Madam Speaker, at the minimum, and I'm not going to make a motion. I'll listen to the rest of the arguments. But what I do suggest is at the minimum, we put this resolution back in committee and have a real public hearing where the people of Guam understand the implications and can come and sit before us. I mean, I like listening to attorneys from universities, legal scholars, rapporteurs from the UN. I mean, they're interesting. They're smart people. But I want to know what Tun Jose and Tan Maria want. That's my proposal, Madam Speaker. Si Diyos Masi for allowing me to express my feelings and comments and why I think this is not a good resolution for this body to pass 5636. Si Diyos Masi, Madam Chair.
Si Diyos Masi, Senator. On the resolution, is there anyone else who would like to be recognized? Senator Moylan, you are recognized.
Thank you, Madam Speaker. You know, the information provided at the public hearing there was a lot of information put out there. It was kind of summarized by our last speaker as well. So I contemplated certain things, and I had to respectfully request, or I'm respectfully removing myself as a co-sponsor to the Resolution 5336 as amended. Thank you, Madam Speaker.
Thank you. On the motion to remove Senator Moylan as a co-sponsor, just a minute. Is there any objection? Seeing no objection, motion carries. Is there anyone else who would like to be recognized on resolution number 56-36? Senator Blas, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I stand here as a co-sponsor to Resolution 5636. And over the last few days, I've heard the arguments in support of and against, in opposition to the resolution. And one of the things I found, I sat here and I read the resolution, and I read it again. And while I see that the resolution says it is in support of a United States House of Representatives resolution, quite honestly, I didn't see that in the resolve. What I saw in the resolve are concerns that we as a people have brought up for decades. What I saw in the resolve and what I saw in the text, the narrative of the resolution, was an opportunity to be able to use a platform that exists, that rarely exists in Congress because of their naivety and their unwillingness to deal with it, is an opportunity to speak again. And I don't see a problem with that. For those of us, and for those of you who know Washington, D.C. and the inner workings of the swamp, there's a thing called out of sight, out of mind. And when you represent a body of people thousands of miles away with really meaningless representation there, I liken this to a Dr. Seuss story called Horton Hears a Who. We are here. Despite what you throw at us, despite what you think of us, despite what you want to do of us, we are here. And I have to agree with the retiring speaker from AFAMI. With regard to our political status, when you talk about political status and you talk about the Insular Cases, two separate things. But when you look at the opportunity to say something, especially with the rare opportunity that we have to say something about how we are affected by legislation that we really have no choice in, but yet are mandated to follow, the opportunity for us to say we are here should not be dismissed. And while there can be some argument as to what is contained in the body of the resolution, I think the spirit of the resolution is what's most important. We can stand at odds as to what political status we think Guam should have. We can stand here and argue about what benefit or what disadvantage the Insular Cases has for us. But what we should not what we should take advantage of, actually, is the opportunity to be heard. You know, I remember in the public hearing there was a presentation, there was testimony that was provided by Melvin Wampat Borja. And I actually had a conversation with Mr. Borja a few days afterwards, and I said, you know, I appreciated your testimony because you know you are exactly right. Because with regards to political status and even with regard to how the Insular Cases affect us, that was something that we already brought to the table to the United States. And when we brought that to the table, the United States said, oh no, we don't like that, go back and change that. What kind of negotiation is that? I'm of the opinion, Madam Speaker, we don't have to go through a political status referendum anymore. We did it already. And while the response that we provided, and which was the right response by Governor Joseph Vada back then, when they didn't want to accept certain points of what we wanted, and they said, go back, you know, you're going to have to change that. And Governor Vada said, I'm in no position to do that because this is what my people want. I think now we should go back and ask them the question, okay, if you didn't want that, what do you want? So, going back to the resolution, okay, so there may be some language in here that doesn't sit comfortable with some people. There's some part of this language too that don't sit comfortable with me. Is it necessary for us to bring this up? Probably not. But it's a great lesson in history for them. And maybe an opportunity for them to come back and say, well, you know what, that's not true, necessarily the truth, or exactly how it went. Let's have that discussion. And this gives us that opportunity to do that. I do have some concerns of what happened over the last 2 weeks with regards to the House resolution. But that's their problem. And I think their bigger problem here is, you're right, while the House resolution says, hey, Supreme Court, maybe you want to chime in on this Insular Cases, come on. As was stated by the gentlelady from America and Samoa, Congress has the tools to be able to make those adjustments. We don't have to go to the courts to do that. So do it. And that's what this resolution says. If you look at the result to the resolution, Madam Speaker, there's nowhere in that there that says that we resolve that we are in full support of House Resolution 279. What this says is that be it resolved that we want, these are some problems, these are the issues that we have, deal with it. That's what it says. This resolution was the vehicle, the opportunity for us to again bring our concerns to that body that has the power to do things. You don't have to rely on the Supreme Court to do it. They can do it. And that's what we're saying. We're telling them, Congress, do this. We're not saying Congress go to, oh, by the way, in your case to the Supreme Court, add this on. No, this says Congress do this. That's what this says. So I stand here as a co-sponsor to this resolution, not in support of 279, in support of the people of Guam, and using this as the opportunity to express the concerns of the people of Guam. At any time we have the opportunity to express the concerns of our people, I don't see that as a mistake. The great thing about our deliberative body is that from now, until this resolution gets moved into the third reading, we have the opportunity to change some language. I challenge my colleagues. Change the language so it'll be comfortable for you, but let's not lose the opportunity to voice the concerns of our people. Thank you very much, Madam Speaker.
Thank you, Senator. On the resolution, Senator Jose Terlahi, you are recognized.
Madam Speaker, tisina na behongi na taisid bihas na resolution. Jadi nancha si Senator Blas na estina resolution tananay ni opinion ta i Congressional America po matsogi hafa malagota. Giro semana na tempo ni utaytay i papit gaseta. Jaleling na ma-deny ni Supreme Court of the United States ma-deny Guam to set the plebiscite. Pesi questionao na jangin malofan este na resolution. Jadi nancha si Senator Blas na TST 279 ta sa poputi gwanin na resolution. Lo tadi klaklara hafa malagota. Gwini kita nota. The questionaho ni mujung ejo na madinay Guam na para tatsogi jota plebiscite. Gagi kinin prediku na komit na i Supreme Court of the United States pat Congressional America. Jonggan si Senator Dueñas dinansi na deputy matulaika i Congressional America di pursiing katgaw ni esti. Lo esti na resolution. Tasangangan ni Congressional America na estigi malago na itaw-taw ta. Onra ifinumami. Tato ko kung siya gwini dos taw-taw ta ni komentus. Lo deputy tana klaro na tisina na para tahunggi na taisit BST Resolution 5636. Sa expliplikas na resolution imalagota data fafasin ni Congressional America Pero ajuda hit. Tati na tempo, madrafo pa militar, minalago niya. Pag umalo mo, gipulisman, madrafo. O aksepta sa malago zo na bay, funan na dyan, isit bisok ko militar. Matago zo pa behano pa begera, ti malago zo gumera. Lo edzigi malago niya, edzigi presidente ng Amerika. Zamanita, zanezo lago siya. Pois David yung maata na hafa finaisasinta gini. Zahesta besangan, Madam Speaker. Na este na resolution tatosuni kambi minalagota. Zatafafasin ni Congressional Amerika. Tananay ni hafa malagota. Kung mansolidano hir para Amerika. Zabinaid ang kulun na si Jus Masi. Si Senator Barnes ni alang mo sasti. Zamunda alang mo sasti si Senator Barnes. Pero esti ani mujung esti Resolution 279. Zaparo ajuda. Pata komplementa 279. Jadi nanti Senator Blas ay tipu di 279 na manutugir gini. Pudi manalagota. Zatanai sansa esti Resolution 5636 UR. Po fatugi Congressional Amerika da mas patan maikungu. Zafafasin hamzu toro ni manita gini kumuman solidanuit. Kumumanita Republican pa Democrat. Mahila data sa potiste na resolution sa pohano esti na resolution guatu ki Congressional Amerika da po matungo ni tauto eju guatu. Hafan na tinanay neju toro na probleo. Toro na fa malagumizu. Pen relocate di militar magi. Tisina fa tasangan. Lomba juria kita tahu tak aksepta na pemadaga magi aja siya na militar gini. Sa tagway jay militar, tagway jay tahu ta, tagway jay tori man solidano. Nemanggay gini. Dispensa jo sa funut sa momoro sa mas gifun English mas open minded gifunut sa moro. Jo fafaisin tori mangatsung gini. Niman manhunggi na esti na resolution ya 5636 esti na resolution po komplementa edi resolution 279 ni malangnas di Congressional America. Si Jus Masi, Madam Speaker.
Si Jus Masi, Senator. On the resolution, Senator Shelton, you are recognized.
Sedus Masi, Madam Speaker, I rise in support of Resolution 56, and I thank the good author for her leadership. Throughout this pandemic, the federal government has played a very large role in assisting our island navigating the health and economic crisis, and they've been great partners in ensuring that our island's people have been able to continue to live as comfortably as possible as we slowly come out of the pandemic. However, we must acknowledge that there have been many historical injustices against the people of Guam. And the insular cases mentioned in this resolution, in fact, were based on racially biased decisions. In an island paradise that prides itself, as the good author said, on being patriotic with the highest enlistment rate per capita in the nation, with many of our islands, women and men in the military to serve the country, despite not being able to vote for president, on an island where only certain parts of the United States Constitution applies, giving the people very limited rights, and on an island that has continued to work with the United States for the betterment of the people. The passage of House Resolution 279 would be only one of the first steps to acknowledging that the insular cases are unconstitutional and non-democratic and have continued to negatively impact our island's people. These cases should have no place in the United States law. Resolution 56 goes to the heart of our plight to make our own destiny. And this is not the first time that the people of Guam had tried to fight against the insular cases. Rather, it is the result of years of tireless efforts to communicate to the United States that our island's people deserve fair treatment. I rise in support of this resolution, and I urge our colleagues to do the same and to encourage our counterparts in the United States Congress to speedily pass H.R. 279. Siduos Masi, Madam Speaker.
Siduos Masi. On the resolution, would anyone like to be recognized on the resolution? Senator Taitagui, you are recognized.
Siduos Masi, Madam Speaker, and good morning to my colleagues. Madam Speaker, you know, I see the intention of the good author of this resolution, and I was able to watch again the video or the taping of the public hearing for this. It was very impressive, actually, to tell you the truth, to see all those people that were there testifying and listening to their views. Very educational, in fact. And then, as I started reading this resolution, wondering if it was going to be substituted in any way, I was trying to go over it and find out whether it made a substantial difference in what we were looking for and what we were asking Congress for. And it was ironic because I saw the section that talked about SSI, and I actually took the time to read the case between Puerto Rico, a gentleman who moved from the US back to Puerto Rico to help his mom, his parents, his family. And then after 3 years, the United States government called upon him to ask him that he was being paid SSI when he should not be because he was living in Puerto Rico. It was very disheartening, and then hearing from Attorney Jacobs to hear the situation with that too as well, it just didn't seem fair. You know, Madam Speaker, we talk about our families who have left the island to seek education and then ask them to come back and give to our island what they've learned to make our island a better place too. We always encourage our family members or those who grew up in Guam, who leave for education, to come back. But sometimes you get all these benefits in the United States that it makes it very difficult to come back to Guam because you're going to lose out. And it almost seems so unfair because we send per capita more people to serve in the United States Armed Forces than any other US state. And we don't get that same privileges as they do. And then it talks, then the resolution then at the beginning talks about the insular cases and the injustices that's been happening. We've been doing that for years in every resolution. And yes, I was in the 30th Guam Legislature when I did support resolutions that talked about the insular cases. Those resolutions were specific about the insular cases. Madam Speaker, that's my concern about this resolution. My concern is not just worried about losing other opportunities we get from the US government, like Section 30 money, like the ability for QC program, the ability to establish our Chamorro Land Trust. I don't think we're going to lose those at all. My concern is just the mixed message that we're sending through this resolution. If we're going to talk about the insular cases, if we're going to talk about the injustice, if we're going to talk about self-determination, then let's send a resolution that just talks about that. Now we're putting in the SSI, which I believe should have its own resolution by itself. It deserves that. And the good author of this resolution mentioned another case that came up. It deserves its own resolution for us to stand behind and talk about. And Madam Speaker, I think every term, every legislature put together should always continue to send a resolution about our insular cases. Every opportunity we can get. But I also want to make it clear that when we do send a resolution to Congress, that we are talking about one subject matter and not two. I stand in support of the SSI, for all the territories. I think everybody does here. And I do stand in Congress addressing the insular cases and being favorable to our island and other US territories, unincorporated territories. But I think if we're going to send a message to Congress, it should be one that's clear and on one subject matter. And I thank the author for this resolution, and the very impressive public hearing that was held. And if anyone that's listening today have the opportunity to watch that public hearing on this resolution, you'll be very well educated on what's been happening for decades and the relationship we have with the United States or the federal government, because, Guam, we are the United States. But our relationship, our federal relationship between the two of us, Madam Speaker, I stand in support of the intent. But what we send to Congress, the message we send to Congress should be clear and one subject matter. Thank you, Madam Speaker, for the opportunity.
Thank you, Senator Taitigui. Anyone else wishing to speak on Resolution 56?
Madam Speaker, if I may, just on a point of information or a point of clarification, if that's okay with you.
Please proceed.
I just want to respectfully state it for the record that based on the resolutions that I was talking about, as referenced back in the 30th Guam Legislature, all these resolutions have nothing to do with insular cases. It all talks about the opposition of the military buildup, and let alone from just appending it into the journal, because it's already in legislative journals, it was Resolution 258-30, Resolution 420-30, Resolution 432-30, Resolution 444-30 LS, and Resolution 275-30. None of them, all of these do not talk about the insular cases. They talk about the anti-military and the opposition too. So just respectful clarification. Thank you.
Thank you for that information, Madam Vice Speaker. Anyone wishing to speak on Resolution number 56?
Point of information, Madam Speaker. I stand corrected, but I do not stand corrected when I support the injustice of the insular cases. Thank you, Madam Speaker.
Thank you, Senator Taitigui. On the resolution, Senator Clint Rigel.
Thank you, Madam Speaker. I rise in support of this resolution. I know that for some people, most people don't really understand what the insular cases are, myself included, until recently. And that's because it's very complicated legal rhetoric argued at the Supreme Court. The average person doesn't really know what it means or what the implications are. So what are they? Essentially what the insular cases are was the US federal government, after acquiring possessions, which includes Guam, we're trying to figure out what to do with these newly acquired possessions. Possessions which, by the way, had human beings living on them. So this presented legal problems, legal questions for the US federal government. Questions of constitutionality. Does the Constitution apply to the people who live in these possessions? How do we treat these possessions? Are we even allowed to take these possessions? Are the people on these islands now our possessions? Or should we let them be free? Should we let them gain citizenship? And if we do let them gain citizenship, how much of our laws, our Anglo-Saxon laws, should apply to them? And in those discussions, when they were deciding how their Anglo-Saxon laws should apply to them, they decided that the people of these possessions were, in essence, not smart enough, not civilized enough to understand these Anglo-Saxon laws, and therefore, not all of these Anglo-Saxon laws should apply. In a nutshell, that's what the insular cases are saying. To me, in a nutshell, that means the insular cases are based upon racist rhetoric and racist ideology. They're the ones who brought the issue of race up first when they mentioned things like Anglo-Saxon laws. Now, for the layperson at home, Anglo-Saxon is referring to essentially the white tribes that populated Great Britain or England, Germanic tribes. And some people may think that, so what's so important about some Supreme Court case that says, oh yeah, the people of the insular areas are not smart enough to understand our laws. What's so important about it today? That was a long time ago, right? That was many, many years ago. The reason it's important is because these cases create precedents. Precedents that are set. Now, I know a lot of people argued and said, well, Congress can change these things and they can grant whatever rights to the territories they want or however they want to treat the insular areas. It's up to Congress to decide. That's correct. Congress can probably do that. But then it can be challenged in court. And if it's challenged in court, courts will look at precedents that's set. And the insular cases have set that precedence, which in turn has guided public policy. Although there's a separation of powers doctrine, inasmuch as there is a separation of powers, all the powers are intertwined because each power relies on the other. So, for example, the Supreme Court relies on the Congress, and the Congress relies on the Supreme Court. It's almost like a vicious cycle. We do it here in this body. Whenever we introduce laws or bills, we'll argue and say, well, there's a precedent set according to this old case that may say that that law is unconstitutional. That's exactly why we have to get rid of the insular cases. Now, I know there's also questions about whether or not the resolution is improper because it cites some things about the Navy and what the Navy has said, and perhaps it's taken out of context. So let's just look at the U.S. Navy report from 1899 to 1950. So it's true that there is a section of the resolution that says the Navy called the people of Guam savages. And that's in here. They basically said all of these areas were savages. There was some concern that it was taken out of context. So let's read some of the context. I have the Navy report in front of me. This is how the Navy report starts. For uncountable centuries before Magellan the Circumnavigator, I would say we should change it to Magellan the Lost, discovered it for Spain in 1521, Guam, the largest Pacific island between Hawaii and the Philippines, was the navel of the world to the seafaring Micronesians. Let's stop right there. First of all, how is it the navel of the world to the seafaring Micronesians? I don't know any Micronesians who refer to Guam as the navel of the world. In fact, this is a misappropriation of Rapa Nui. Rapa Nui's original name in its language meant navel of the world. So first of all, they're completely off base. Let's keep going. Navel of the world to the seafaring Micronesians who made yearly trading voyages thither in fleets of flimsy outrigger sailing canoes. Flimsy outrigger sailing canoes. By the way, these are sailing canoes that Western science has yet to figure out how to accurately recreate or accurately construct using the materials available to the islanders of that time. These are flimsy outrigger sailing canoes that the islanders used to populate the entire Pacific without any compass, without any maps, but with an ancient system that modern science has yet to fully understand. Yet these are flimsy outrigger sailing canoes. How diminutive. Let's read the next paragraph. Then came the white man in caravels whose stone-shotted cannon and arquebuses were deemed by 16th century standards the best instruments for the civilization of pagan savages. Now it's true, in the next sentence, they say something nice. This next sentence is where they throw the proverbial bone at the pagan savage. In the next sentence, they say, the proud Guamanians, the super race of the Pacific, possessing an indigenous and complex civilization, well adapted to their environment, fought back. Great. One sentence where they threw a bone at the savage. The next sentence, their bone-tipped spears were no match for gunpowder and lead. Their ancient witchcraft impotent against the Christianity of the zealous Spanish padres. I can go on, but let me just go to the very next paragraph. By the time Guam fell without resistance to the USS Charleston in 1898, the Aboriginal culture had been destroyed. And the only traces of the ancient language were in words which the conquerors adapted and made part of the implanted Spanish. False. It was the native Chamorros who took in pieces of the Spanish language and incorporated it into their ancient language, which still survives today. And the Aboriginal culture still survives today. The next sentence, it was a decimated, spiritless, and mongrelized population that the United States Navy was called upon to administer and rehabilitate. Rehabilitate? Like some criminal? I don't know why we're up here arguing why the insular cases are racist or wrong. It's very plain and simple to me. Look at all of the writings of the day, the thoughts of the day. This was a type of policy that America took upon at that time and that believed in. All we're saying with this resolution is that we should do away with that backward thinking. All we're doing is calling out what is racist rhetoric and racist thinking because it's affecting us this current day. Again, the insular cases set precedents. We're asking to wipe away that precedence and give us a clean slate so that the people of Guam and of the insular areas, all of these possessions, can one day self-determine their destiny. Thank you, Madam Speaker.
Thank you very much, Senator Rogel. Anyone else on resolution number 56? On the resolution, Senator Mary Torres, you are recognized.
Thank you, Madam Speaker. Madam Speaker, today is the anniversary of the George Floyd killing, which caused a massive uprise in the consciousness of America, in the All Lives Matter movement of America, which decried racism. I rise in support of this resolution, and I want to point out that the insular cases were decided by the same Supreme Court that allowed separate but equal segregation in the Plessy v. Ferguson case in 1896. And I quote from the Harvard Law Review article, "As a legal matter, Plessy v. Ferguson invented a legal doctrine of separate but equal, which provided constitutional cover for America's system of racial segregation. The insular cases, fueled by the same racial impulses as Plessy, devised a new category of unincorporated territories, providing a constitutional justification for ruling the populations of overseas territories without regard to traditional constitutional limitations or democratic principles." I was very much engaged, Madam Speaker, in the public hearing that had a very impressive panel of people who testified in favor. Legal experts, legal scholars, people very interested in equal rights movements. And the support for this resolution was overwhelmingly in favor. I did not see testimony that was opposed to it, although there was qualified testimony in support. And the qualification just pointed to circumstances where the insular cases, and I'm quoting Julian Uggan here, were used as a shield and not necessarily a sword in certain circumstances. But I want to point out how the insular cases really is, as pointed out by the Committee on Natural Resources in their March 10th letter to the Department of Justice, more broadly, the systemic discrimination against the 3.5 million Americans living in the territories, more than 95% of whom are racial or ethnic minorities, is rooted in a series of racist Plessy-era Supreme Court decisions collectively known as the insular cases. These insular cases have been called central documents in the history of American racism, with justices in those cases calling the people of Puerto Rico and other newly acquired territories half-civilized, savage, ignorant and lawless, and alien races. This, Madam Speaker, were the words used to describe you and I, and those that came before us, you and I. In America, to advance civil rights, it was necessary to overturn Plessy v. Ferguson. Again, quoting from a Harvard Law Review article, outside the courtroom, Thurgood Marshall and other civil rights leaders realized that in order to advance civil rights for African Americans through the political process, it would be necessary to overturn Plessy. One cannot imagine the 1965 Voting Rights Act and the other landmark civil rights legislation of the 1960s in the absence of Brown v. Board of Education, overturning Plessy and recognizing that separate is inherently unequal. A history of failed attempts to address the underlying inequality in U.S. territories shows the same is true for Americans living in territories today. Until the Insular Cases are overturned, disenfranchised and marginalized Americans in the territories will continue to look in vain for solutions from political branches. Just as it took Brown v. Board of Education to create a political environment where civil rights for Americans could be imagined, it will take a rejection of the Insular Cases to open a political space where fundamental changes to the undemocratic status quo in the territories finally become possible. I want to point out also that the Insular Cases and their legal offspring are embedded in the territory's exclusion from federal programs such as the Supplemental Security Income Program. The case United States v. Vallejo Madero will be considered by the U.S. Supreme Court. It concerns the exclusion of Puerto Rico from SSI coverage. In its briefs for the Supreme Court, the U.S. Justice Department cited two precedents to support its position. One is California v. Torres, second is Harris v. Rosario. However, and I quote, "The legal foundation upon which Califano and Harris are built is not good law," according to Vallejo Madero. Those cases attributed Congress's power to discriminate against Puerto Rico to the island's territorial states under the Insular Cases, a much criticized line of cases that are long overdue to be overruled. In the Schaller v. U.S. Social Security Administration in Guam, Ms. Katrina Schaller of Barrigada, Guam, who filed a lawsuit in District Court of Guam in December of 2018, Katrina and her twin sister, Leslie Schaller, both live with myotonic dystrophy, which severely inhibits muscle function and other critical aspects of daily life. Leslie is able to live independently in Pennsylvania due to the aid she receives from SSI. Katrina, however, is ineligible for the same SSI benefits received by her twin simply by virtue of her geographic location. As attorney Rodney Jacob, who serves as Katrina Schaller's counsel, eloquently stated, "It is contrary to common sense, human decency, and sound public policy to deny public benefits to all other Americans with disabilities living on Guam." Madam Speaker, I bring up these points because it is now time to be on the right side of history, to reject the Insular Cases that are rooted in racism, that have no place within the constitutional framework, to be relied upon for decisions going forward. There are many concerns about what this resolution means, what throwing out the insular cases mean. It means one fundamental, critical point. That is, you decry the framework from which these cases were based. This legal doctrine of separate but equal, which provided constitutional cover for America's system of racial segregation. That will continue to loom over the territories. Its time has gone. Its time to be not relied on is now. Let's be on the right side of history. Let's support House Resolution rejecting the insular cases based on its lack of regard to traditional constitutional limitations or democratic principles. Today, the U.S. will acknowledge and reminisce on all the inequities that came about, that resulted in the death of George Floyd. An incident that will forever change history, change the mindsets, change the consciousness of our nation. We ought to change the conscience of our nation. We are not savages. We are not an alien race. We are not separate and unequal. We are not separate, but equal. My colleague from Jotnya, speaking in our vernacular, was correct. There's a lot of merit to this. Let Congress know how we feel. But let's also consider that the insular cases were a series of cases. Our status is a result of federal law. And as we recognize in this body, laws are fluid. Laws can be repealed, can be amended, can be changed, can be newly enacted. Many who spoke at the public hearing talked about rejecting the insular cases as a first and necessary step. A first step. It is up to Congress in their good conscience to do right for all its territories after all these years. But first and foremost, it must first be a recognition that the insular cases and the basis for which they were decided is racist and obsolete and has no place in our American system, especially as it is relied upon to decide all future cases that are brought before the Supreme Court. And with that, I rise in support, and I hope that one day, as 70 years ago, many in these halls stood up for Guam and her people when they demanded to be recognized by the U.S., to be given citizenship by the U.S. That was a cry for some sense of recognition that they were as human, that they were not alien races, that they were not savages. Let's take it further 70 years. Whatever we can do to start that dialogue, to start that process to undo the insular cases, that is our place in history right now. And Madam Speaker, I want to be on the right side of history. This is the correct thing to do. I want to be on the right side of history. Decry racism, reject the insular cases. That is a savage law, an obsolete savage series of cases and decisions by the Supreme Court. And God bless Guam. And may she in the next 70 years find her way, as our predecessor 70 years ago looked at what could be a possible journey for us. How do we help bring our people whole? How do we help dignify our people? Rejecting the insular cases, in my opinion, is one way to bring some dignity to us by erasing that ugly history. Because really, everything about there that describes us is about you and me. And I don't believe it describes what I think you and I and our people of Guam and the territories are. So with that, I rise in support, and I plead with my colleagues to have an open mind. This is our time in history. And God bless the soul of George Floyd and all the good conscience that his death evoked. Thank you.
Sidious Masi, Senator Torres. Anyone else wishing to speak on resolution number 56-36? Speaker Terlahi, you are recognized.
Thank you, Madam Speaker. I wish I could be as eloquent as those who have preceded me today. I want to echo their sentiments as to, we as Chamorros being described in the way that those cases have described us, of course, and I want to pay honor to those who have preceded us in this battle, and especially I want to thank the author of this resolution for her work, and as is previously stated, the very impressive public hearing that was held here on Guam, for her ability to submit testimony to Congress, for the Congressional hearing on the resolution in Congress, for the scholars that were invited to give input, and for the knowledge, I think, that has grown because of this resolution here on Guam and, very importantly, in the United States, among the citizens of the United States. And I think that is important, and that is always our goal and should always be our goal. The more everyone is educated, the more injustice can be rectified, I believe. And so I want to thank everyone for their support of rectifying these injustices. And the injustices were very clearly spelled out during the hearing over the decades. And unfortunately, Congress is not that well aware of them. But I do agree that it is within Congress's power and authority to rectify many, many of these things. Many of the things that the courts are interpreting or declaring valid are laws passed by Congress or other entities, and declaring those to be valid, declaring that that type of discrimination is okay, allowing, as the congressman of the Senate President of the CNMI stated, allowing resources to be taken without consent of the government and the people. And allowing disparate treatment in federal programs. But so I think I have looked to Congress, and now I'm looking to the President and the cabinet of this President to do what they have promised to do, and that is to take a look at the territories and to rectify the injustices that are occurring in the territories. And so we have seen a slew of bills in addition to the resolution that our current resolution describes. We see that there's increased call for these types of things in Congress, including the HR1 that was talked about earlier, There was H.R. 265 to eliminate Medicaid funding limitations for U.S. territories. H.R. 17, 2022, amending Social Security Act to stabilize the Medicaid program in Puerto Rico. H.R. 537 to extend SSI to Puerto Rico, U.S. Virgin Islands, Guam, American Samoa. H.R. 1773 to make the Commonwealth of Northern Mariana Islands eligible to operate TANF programs. There was Senate Bill 865, which is to recognize the right of the people of Puerto Rico to call a status convention through which the people would exercise their natural right to self-determination and to establish a mechanism for congressional consideration of such decision and other purposes. H.R. 2070 to recognize the right of the people of Puerto Rico to call a status convention through which the people would exercise their natural right. This is the one in the House. And so I agree with my favorite part of this resolution that we are looking at today here on Guam is the part that was added after the hearing that says, whereas Y Legislature in Guam urges the United States Congress to further rectify the injustice imposed on Americans in the territories by engaging in a binding political status reconciliation process that is tailored to each unincorporated territory, with the residents of each territory being a party to these discussions. I wish this resolution said only that I completely support. And I thank the author for including that because rejection of the insular cases it has implications. And if we are not going to determine what those implications are going to be afterward, I think, I have concerns about that. I think we should be very, very specific what we are asking for, and that so that we do not get something that we do not want. For example, one of the scholars, I think at the public hearing, described, that a lot of them described how after this resolution, of course, Congress has to take some action. And perhaps, they should consider tribal status. And those are the types of things, Madam Speaker, that I am concerned about. I do not want our future to be determined without our consent, without our input, without our determination of that future first, and dictating to Congress, what we want. And they clearly have the power to assist us in that regard. And so does the United States President and their cabinet. The resolution, so the Guam Resolution is in support of a House Resolution H.R. 641, which asks for three things. It says, resolved that the House of Representatives recognizes the importance of supporting equal rights and upholding the interests of Americans living in the United States territories. 2, acknowledges that the insular cases rest on racist and imperialist assumptions that have no place in the constitutional landscape of the United States. And 3, reject the insular cases and their application to all present and future cases and controversies. And while it sounds at first glance to me, of course, absolutely, we all reject the racist and imperialist assumptions that were made at the time, that continue to be relied on now, and that continue pretty much. But I am worried about, especially the last part that says we reject the application of these cases to present and future cases and controversies. And that is the only reason we are having, not only us, but the scholars who presented testimony on the hearing are having they were not all clearly in agreement as to whether we want to wipe these insular cases out or use them to improve, and for Congress to take action as it should to rectify what has occurred because of them. And I am not a legal scholar, although I am a lawyer, but I do want to say today that I very much appreciate the legal scholars for their work, for what they have contributed, and I think it shows that, and I want to point out one of the testimonies submitted by Blue Ocean Law. It was authored by Attorney Julian Uggan, May 10th, submitted to the committee. And if I could beg your indulgence, I'd just like to read excerpts from this because I think it's important to put this on the record. And my position on this matter is very much predicated on this type of thinking that there are unknown, unforeseen consequences. So he writes, "Dear Vice Speaker, I write this testimony to express my concerns relative to Resolution 56-36. I wish to join the chorus of legal scholars who have testified in favor of this resolution, but only to the extent of denouncing the insular cases and their racist and imperialist origins. As these scholars have already articulated, the insular cases and the territorial incorporation doctrine for which they stand gave constitutional blessing to the colonial enterprise rolled out at the turn of the 20th century, and they continue to provide cover for the disparate, unequal, and mostly unjust treatment of the territories to date. That said, it would be a mistake to think that House Resolution 279, the Congressional resolution which your resolution supports, is a solution to the territorial problem. It isn't. It is a symbolic first step in the right direction, but it is also problematic. And worse, if we are not careful, it could set us down a path that is lined with unforeseen consequences for the indigenous peoples of the territories. Setting aside whatever legal mischief has been done in their name, and to be sure there has been no shortage of it, the insular cases provide the basic analytical framework that federal courts in more recent decades have used to protect the indigenous people of the territories. In particular, their land, culture, and self-governance rights. For instance, in the CNMI, the case of Wabo v. Villacruzes, the court invoked the insular cases to uphold an ancestry-based land alienation restriction against an equal protection challenge. For all its flaws, the impracticable and anomalous test, a standard that arose out of the insular cases in order to judge whether a particular constitutional provision applies in any given cases, provided a framework for upholding the restriction that was put in place to protect the land and culture of those persons of Northern Marianas descent. And that was an integral part of the bargained for exchange between the US and the then newly constituted CNMI. Moreover, without access to this standard, which commands a searching inquiry in every case, the land alienation restriction in question would have almost certainly be struck down under traditional equal protection analysis. To take another example, in American Samoa, in the case of Tuawa versus United States, the insular cases were once again more shield than sword, protecting against what many in American Samoa, including the territorial government itself, considered to be an imposition of citizenship by judicial fiat. And while I agree with many of the finer points of constitutional law raised by legal experts who served as amici in that case, I cannot ignore the fact that so many people actually living in American Samoa vociferously opposed the case and the relief that it sought. I may disagree with the insular cases, but not enough to undermine the clearly expressed wishes of colonized people. I can think of no greater affront to the right of self-determination than that. In addition, I am not convinced by those who argue that the rejection of the insular cases, even if problematic, would still do more good than harm. This argument presupposes that equality is always the most important, if not only, political project. But it isn't. Getting out of the Union is as valid a project as getting in. Again, setting aside their racist and colonial roots, the Insular Cases also, as leading constitutional lawyer Christina Duffy Ponce Krause has suggested, effectively smuggled a theory of secession into American law. To be sure, though the standard account of the Insular Cases is that they give judicial sanction to American imperialism by withholding from those territories acquired after the Spanish-American War all but a few constitutional protections, and by denying them the promise of eventual statehood via the unprecedented doctrine of territorial incorporation. Another reading of the Insular Cases, relevant here, posits that their more important content is that they authorize territorial de-annexation, namely that they make clear that the United States retains the power to de-annex so-called unincorporated territories, those places not incorporated into the United States but merely belonging to the United States as non-state possessions, even after said territories have become subject to exclusive US sovereignty, even after Congress has begun to govern them under the territorial clause, and even after their inhabitants have been made US citizens. In her article, Ponce Krause explains that per the Insular Cases, an unincorporated territory ought to be understood as a special category of domestic territory that is not bound in permanent union to the rest of the United States. And she writes, a de-annexationist interpretation of the doctrine of territorial de-annexation serves the aims of self-determination by preserving the option of separation for any territory subject to the US sovereignty and federal law, but denied equal representation through statehood. Read this way and considered in light of the 20th century developments in the idea of self-determination, this doctrine can be understood to provide fundamental safeguards against the formal and permanent installation of colonial inequality. I'm just going to read that one part again. This doctrine can be understood to provide fundamental safeguards against the formal and permanent installation of colonial inequality. It confirms the transitional nature of a subordinate status, while ensuring that both full integration into statehood on an equal footing and complete separation into independent nationhood remain available as alternatives that the inhabitants of a territory might choose. As long as the territory's relationship to the United States does not ensure equal participation at the federal level, that territory's potential separation from the United States should not, and the Insular Cases tell us cannot, be ruled out. Unquote. So the question becomes, what does the wholesale rejection of the Insular Cases mean, really? And I'm still reading from Attorney Julian Uggins here. I submit that this is not only a fair question, it's the more important one. Does doing away with the Insular Cases mean doing away with this special category of domestic territory? What happens next? Do we revert to the once prevailing assumption that all territories are en route to statehood if the failure to incorporate a territory serves the function of retaining the option of separation? Does that option evaporate when the Insular Cases do? Surely the price for equality cannot be self-determination. In closing, in our zeal to condemn the Insular Cases, let's not do so hastily. Let's not relinquish the bigger confusion for the smaller certainty. That serves no one, least of all the peoples of the territories who continue to suffer under the colonial yoke and who long to be free. And as I recognize that, and I want to thank Attorney Uggin and all of those who submitted testimony, it's really, I think, been very helpful for all of us. It's imperative. This is a tough call. I want to stand in unison with all of my colleagues, and I want to say, down with racism, down with, disparate treatment of the territories, but I will not stand to say, take away my rights for self-determination, and I will not stand for any type of determination of that future by Congress without our input and our consent. So again, thank you to all my colleagues, and thank you, Madam Speaker.
Thank you very much, Speaker Terlahi. Anyone else wishing to speak on resolution number 56? Senator Brown, you are recognized. Senator Perez, you are recognized.
Masi, Madam Speaker, and it's really hard to come after great speeches today, but I do want to, perhaps register some thoughts regarding Resolution 56-36. And I think hearing all this, the testimony today, it shows that I think Guam is truly at the crossroads for decolonization. Great awareness and consciousness about the injustices of the past have come to light and come to the forefront, not just here on Guam, which has happened for so long, but now in the U.S. Congress. And I see the excitement, that our issues are now becoming at the the forefront in the national scene is something that we've wished for so long. We wish to see our issues become front and center in the national stage. And this is something that when we talk about the remedies for decolonization, the U.S. is very an integral part to this. And I think that's why there's so much energy behind this. And I think all of us here can agree that we denounce the racist policies, the racist policies and ideas that came out, the rhetoric that came out of the Insular Cases. And just to kind of highlight some of the testimony that was provided during the hearing, there was one that what Insular Cases does, what in effect does, it permanizes colonialism. And that's one reason why we need to denounce it. If we are to achieve justice and decolonization, we have to speak out against the very root causes of our status. And to also, as a retiring speaker said, there are complications. So again, going back to the resolution, there are 3 resolved clauses. One is to denounce the Insular Cases. The other is to apply all constitutional and democratic principles to states and territories. And the third is to reject the Insular Cases to present and future cases. So I think, too, one of the things to think about when we talk about application of constitutional law, as we know here on Guam, it seemed like whatever part of the Constitution that benefited the U.S. applied, and what didn't benefit didn't apply, or ones that didn't benefit the U.S. but perhaps benefited us did apply. And I think there is a cautionary note to that as far as rushing to incorporation. I think this kind of speaks to the idea of greater incorporation to the U.S., in that doing so, it may undermine our rights to self-determination, which it goes beyond incorporation to also independence and free association, so gaining more autonomy. So I think that's one of the perhaps cautions behind fully accepting and endorsing House Resolution 279. And I think, too, with Guam, it's important to look back at our history as well. That, equity is something that we have strived for throughout our colonial history. And it's something that we have sought since colonial powers changed hands over our islands. The Insular Cases underlie a much deeper issue at the heart of the United States relations with Indigenous First Nations people. When convenient, we are included. When inconvenient, we are excluded. Our islands are continually exploited because we have no equal footing. Much of it is rooted in antiquated and racist views of Native peoples. But this is not just an issue relegated to Native peoples. We are merely the baseline for fair and equal treatment. If it can be done to us, it can be done to anyone else who is considered foreign, other, or alien. And so, yes, this resolution brings to light that we must denounce racism. But I think as the others who have testified, for instance, Dr. Underwood, we cannot be complacent with that. We actually need to seek the remedy and strive for the remedy and be consistent about what we ask for. And I know that some of those previous speakers talked about use of plenary powers. Yes, I just want to bring to the attention of the public, we've been seeking remedies since our relation with the U.S. began, and we will continue to do so. But we must also work together to ensure that we are not undermining our full potential for decolonization. Sidus Masi.
Sidus Masi. Senator, on the resolution, is there anyone else who'd like to be recognized? Senator Brown, you're recognized.
Thank you very much, Mr. Speaker, Madam Speaker, for the opportunity to speak on Resolution 56. Certainly a lot has been said this morning with regards to this resolution, and I think we're always individually challenged in looking at the history of Guam. I mean, being born and raised here myself, having lived here most of my life, trying to understand our history and certainly the injustices that have happened as a result of that, because we have a view certainly that we have a right to our own determination and that there should be no discrimination, that we are all equal. I think we all have those challenging feelings when we understand the history of what our people have gone through from the time of what we call contact, because that contact is defined, because supposedly Magellan landed on Guam, and that's when we determine contact, versus the fact that our people have been here many, many years prior to that. Whose history do we follow, and whose history do we define ourselves with? I think we recognize the language that's included in the Insular Cases are discriminatory. I don't define myself by those definitions. I don't think many people do. It's unfortunate, and simply because it was written, we have a tendency to see when somebody puts something in writing, and in this case, because of the significance of how we look at these cases, that's what is. That's what we measure ourselves from. I certainly don't personally. So I kind of take it in just what was written at that time. That doesn't define who I am today. We have many views with regards to our political status issue, and certainly I'm very supportive of the fact of our people to ultimately vote and decide what status they want and what they desire. I myself, I've always looked at it from the perspective, even though I have 2 of my degrees in government and political science, I've always looked at how does Guam position itself to its best advantage. Does that mean statehood? Personally, for me, not. Do I want to be fully incorporated into the United States? I see the advantages, but I also see the disadvantages of that. Do I want to be independent? I look at that road and see the advantages. Then I also see the disadvantages of that. I don't think there's any perfect status. The United States in and of itself still wrestles with the issues of discrimination to this very day. Even though, we profess and say that, we are all created equal. That's not the case. We all have our own personal sense of discrimination, be it by the color of our skin, the level of education, our financial status. It goes on and on. Even to this day, our mother country, well, some may view it as such, others don't, is still challenged with the issue of discrimination. The fact that we see what happens now almost every day. And, laws continue to be passed to ensure that we don't discriminate against each other, be it our race, our sexual orientation, our economic status. I mean, the list goes on. How I look at this issue is in terms of where does this position Guam politically? Where does this put us in the world? Where do we maximize the advantages and benefits to our people? I've never looked at it as full incorporation. I kind of look at it as how do we find that balance? That we have the benefits of the U.S. flag, because if it's not the United States, let's not kid ourselves. There's not any major country in this part of the world that would allow us to live in total peace and harmony. be it China, North Korea. I mean, goodness, you think these metropolitan countries would pass the opportunity of not wanting to expand their footprint in the Pacific? And Guam has benefited tremendously from our position on the globe, which we had nothing to do with. That's, I give that to God of putting our island here where it is. We continue to benefit from it. So that's the challenge, is how do you come to terms with that reality of our history? We look at the Spanish and go, well, they colonialized our island, they killed our people, they indoctrinated us into Catholicism. How do we address that issue of, our indigenous people and the purity of their lives and the impact of our lives with Spanish influence, that we are Catholic, majority of us are Catholic. Those things don't mesh very well. There are differences that take us down different paths as we want to specifically look at those issues. Of course, as we look at our history, for those of us that were born after the war, to think of what happened, the atrocities that happened to our people, and those of us that are descendants of the Chamorros that lived during the war. We all have the scars that we know of our parents, or in many cases, as in my case, because my mom was born after the war, our grandparents suffered, our aunts and uncles suffered, our cousins suffered, our brothers and sisters suffered. There's nothing that we can say that could justify that, what happened, or come to terms with and never accept it, because it was such a time of sorrow, such a time of suffering. And then how do we justify, again, our what we call our colonializer, the United States of America? As we carry our U.S. passports, as we have so much of our familia, Madam Speaker, who live in America. Majority of our Chamorros live in America. So maybe if we were to choose, maybe our people would want to continue their relationship and their union with America. I myself have always made the choice to live on Guam. At a personal level, it's always been my desire. Even though certainly I, as many of us have here, and other cousins and relatives of ours, have had the opportunity to live off island and make their home elsewhere. For me, it's always been a choice. I never doubted I would come back home, because this is home for me. So we all have to wrestle with the not-so-pleasant history of what has brought us to where we are today. And in that whole situation, I've always, as I mentioned earlier, I'm always looking for the balance. Where can we position ourselves so that we can get the maximum benefit in our political status? Because there's nowhere else around us within the region, aside from the metropolitan countries, there's no other island in the region that has the economic benefits Guam has. To a certain degree, the Northern Marianas, but I think everyone will look at Guam and still see Guam as the center of that activity for opportunity. That's why we have so many neighboring islanders migrating to Guam. We denounce the United States, and justifiably so. We can argue the language in the Insular Cases that we feel are not acceptable, that try to diminish us, call us things that we know we are not. But I think we need to look at the bigger picture, is where and what does that put us with regards to our relationship and what our status is? What does it give us? We're very quick to define what it takes away, but we're not discussing what it gives us. We talk about Section 30 money, like it's no big deal. Well, it's a big deal for the government of Guam. We wait every year for Section 30. We talk about how, back in the day, you talk about, Senator Chris talked about, one of his favorite governors, who's also one of mine. Back in Temponada, we were lucky. We got, 30 million, that's big bucks. Well, we get more than that these days. We have substantial federal grants that we benefit from. And certainly in the most recent unfortunate circumstance of this pandemic. So I look at that and go, okay, let's see what the benefits are that Guam can get. Yes, we argue SSSI doesn't equally apply to Guam. You know, we're always caught up in that situation, Madam Speaker, where it's which side of the line are we on? If we're American citizens in the continental United States, then we get all these benefits. But if we're residents of the continental United States, we also have to pay federal income tax. I actually like the fact I don't pay federal income tax. I think most of our people on Guam probably like the fact that they don't pay federal income tax, but receive the benefits of federal income taxes. So those are the issues that I look at. And I, by all means, any special status that we can get, I'm right there. I look at Guam as the center of the world. I can go anywhere pretty much from here, so I don't feel trapped on my little island. I'm very prideful for the fact that I live here, that I invest my time here, that I invest my resources and my family here. I'm very proud of that. You know, my grandfather, when I was very young, Madam Speaker, you know, of course, I was of a generation, as many of us were, that were raised to speak English as our primary language. I thought I was pretty good at English. And my grandfather always talked to me in Chamorro. And I would say, Grandpa, you need to talk to me in English because I don't understand. I don't understand what you're saying. He said, Ayagal. And he told me in Chamorro, Joanne, you need to appreciate your Chamorro culture and your Chamorro history. It's a part of who you are. Yes, America has its benefits, but you need to know who you are here. And I have to tell you that as a young child, he only spoke to me about that once, and I understood. That's why I am very prideful of who I am and where I come from. Because there is so much about our people and our culture that I value. And that's why I always want us to be positioned in the best position we can be. And I think we need to look at those issues. How do we benefit and maximize ourselves? We get these benefits, but we don't pay federal income tax. So I would never, these options. Do you want statehood? Do you want independence? Not quite. Because I don't know that there's independence. There's a price to that. I don't want any other country dominating Guam. Unless our little island, we're prepared to protect our borders in the great big world of realpolitik. We can talk about our deals because we're free to do so. We talk about the fact that, so many of our own largest percentage in the entire United States of America serve in the armed forces. And we're prideful of that. I come from a military family. My dad spent 24 years in the Navy. My dad's a combat veteran. Many of us, if not ourselves, immediate family members, children, uncles, cousins, aunts, very much so, very much part of our island. We're very patriotic. Yes, does Congress pay attention to that? Does it matter to them that we're probably the most patriotic Americans? Granted, we've had to fight for every step of the way. Every step of the way the people of Guam have had to fight to stand up and be counted. It's never been granted to us. Even the issues and imperfections that we look at in the Organic Act, that wasn't granted to us. We know the history of our people that went and fought for that, for every step of the way. But while we try to wrestle with the injustices of our history, because there's no country in the world, I highly doubt, not that I study every single country in the world, that doesn't have their sordid history, that doesn't have their issues of discrimination and domination and abuse of others. You don't become sovereign automatically. It doesn't get granted to you magically. There's imperfections in that process. But I think we need to look at the bigger issue of where does this position Guam with regards to the insular cases. So I'm looking beyond the issues of how others may have defined us with regards to this, because I don't define myself by their definition. And for me, I always want to position Guam in the best position. How do we take advantage of our relationship with the U.S.? If it's SSI, yes, let's break away and pursue SSI so that we can get that benefit. How come our neighbors up north get it and we don't? Especially for those that are in tremendous need. That's how I look at the picture, Madam Speaker. I can intellectualize and understand the whole issues of independence and self-determination. But I also know many of our people are not going to want to give up what they have either. But that's just human nature. So I do appreciate the efforts and the discussion that has been put forth. And I did, listening to the public hearing, it was very informative. We don't always have to agree, Madam Speaker, on every issue. I think that's the dynamics and the beauty of the debate, because very few things are on one side of the road. Doesn't mean we think any less of each other if we don't agree. But as I mentioned, I think there's a little more to this issue with regards to the bigger position of where this places Guam, where this places the other territories. And I always want to see how we can maximize that relationship to our benefit and not carry the burdens that come with that relationship. Freedom is not free. Freedom is not free. We were all growing up wanting to get on our own, have our own homes, drive our own cars, stay up as late at night as we wanted to. Even though now we can do that, we're probably too tired to want to anymore, even though we're free to do it. Once you break away from mommy and daddy, wow, that mortgage or that rental or that car payment or that grocery bill, all those things that got taken care of for us, got pretty expensive. So I just think we need to look at that. That doesn't mean I'm pro-US. I think there are a lot of things in the history of the United States with its relationship to Guam that is shameful, that need to be addressed, that need to be acknowledged. In a couple days, we're going to go celebrate Memorial Day. And for those of us that have lost family members in war, and I have, I think of that every time I drive by the Veterans Cemetery. As many of our people have lost. So there's a part of me that will love the United States and a part of me that doesn't appreciate some of the things of our history. But I always want to see where we can benefit and position ourselves to the best of our advantage. And maybe that creates a whole different status other than what's been put forth for us. And I leave that to our people. But I think we need to look at the issues from all sides and, as I mentioned, maximize and benefit and position Guam where is the best position for us in this relationship. Rather than looking towards the past, I think we need to invest in that future and make sure we're in the best place we can possibly be. With that, Madam Speaker, thank you very much for the opportunity to provide some comments on Resolution 56.
Senator. On the resolution, is there anyone else who would like to be recognized on the resolution? If not, then I'll ask the sponsor to please close on the resolution.
Madam Speaker, for giving me an opportunity to close on this resolution 56-36 COR. I do want to thank my colleagues here today. I want to say, Madam Speaker, I appreciate the dialogue, the passionate exchange that fundamentally defines what we all know as democracy. While some have stated that this is about self-determination, while some have stated that they think we should be a state, and while some are afraid of the unknown, I want to go back to what this resolution is about. We have a problem. Our problem is that the Insular Cases set a precedent that treats us as less than American. As a result of these ideals, this has translated into disparity for SSI recipients, disparity for access to health care, and Madam Speaker, the list goes on. Acknowledging the racist discourse that is the foundation of the Insular Cases is the first step. And as I stated in my testimony before Congress regarding House Resolution 279 and in my letter to Vice Chair Khalili Sablan from the Northern Marianas, CNMI, who is a co-sponsor of H.R. 279, Congress has the power today to make right the injustices of the past through their plenary powers. That same delegate established in testimony before Congress while questioning the same Rutgers professor that the insular cases could be rejected while still protecting land rights in the CNMI via the plenary powers of Congress over the territories. Madam Speaker, the CLTC, Section 30, and the programs we enjoy today can be preserved. However, full access to SSI and Medicaid and SNAP is prevented by insular cases. We are in a political purgatory because of these insular cases. The points the good senators has made regarding equality cannot be done without overturning the insular cases, which has been acknowledged by legal scholars. I want to also say that while I appreciate my good colleague today committing to a plebiscite and even wanting to fund it, Madam Speaker, I cannot wait for the bill to come to this floor, and I will hold him to that. But today, Madam Speaker, there is no bill in place to do that. Today, we have Congress saying, let's make progress to ensuring parity to Americans in the territories. Today, we are talking about supporting Congress's efforts to make right with the territories. Today, we are further urging Congress that when you want to talk about our future, bring us to the table. I end with the reasoning from Downs v. Bidwell, one of the insular cases which reinforced the separate but equal doctrine in the territories. The majority expressed concern over admitting unknown islands people with an uncivilized race to the United States. I know some members of this body, myself included, would prefer a closer relationship with the United States. So how can we stand in defense of a doctrine that says we are too uncivilized to even be given that choice? Madam Speaker, I only ask that my colleagues please help us continue to fight for our people. At this time, Madam Speaker, I'd like to add two sponsors to the bill. A motion to add a Legislative Secretary Amanda Shelton, and of course, as committed, Senator Mary Torres to the resolution, if I may.
On the motion to add sponsors to the resolution, is there any objection? Seeing no objection, motion carries.
Thank you, Madam Speaker. And again, I ask my colleagues, please, I know based on the committee hearings, based on the information received, based on the presentation by scholars, based on information as received as recent as several hours ago, please know that this is a vehicle and a drive for us to help move our island issues forward. So I ask my colleagues to please help me support this effort. Sana Masi, and at this time I'd like to move that resolution 56-36 as amended be moved to the voting file. Third reading.
Thank you, Senator. On the motion to send resolution number 56-36 to the third reading file as amended by the author, is there any objection? Seeing no objection, motion carries. Assistant Majority Leader, Senator Shelton, you are recognized.
Sedilus Masi, Madam Speaker. Notwithstanding the House rules, I move that we go back to motions.
On the motion to go back to motion notwithstanding the House rules, is there any objection? Seeing no objection, motion carries. We are now under motions. Senator Shelton, you are recognized.
Thank you very much, Madam Speaker. I move to place Bill number 110-36 COR onto the session agenda.
Could you please read the title?
An act to amend Section 41649 to Article 16, Chapter 4, Division 1, Title 26, Guam Administrative Rules and Regulations to amend Section 67.308.1 of Article 3, Chapter 67, Title 9, and to amend Section 12605.0 of Article 6, Chapter 12, Title 10, Guam Code Annotated, relative to allowing electronic transmission of prescriptions for Schedule 2, 3, 4, and 5 substances. Sponsored by Therese M. Terlahi and Talina Cruz Nelson.
This bill is available on the motions folder on the drive. Is there any objection to the motion to add Bill 1110-36 to the agenda? Seeing no objection, motion carries. Senator Paris, you are recognized.
Thank you, Madam Speaker. I move to place Bill 104-36 as amended by the Committee on Environment, Revenue Taxation, Labor Procurement, Statistics, Research, and Planning, sponsored by myself, Senator Sabina Flores Paris, co-sponsored by Speaker Therese Terlahi, Senator Anthony Addis, Senator Joanne Brown, Senator Chris Dueñas, Senator Talina Cruz Nelson, and Senator Taloti Taitagui. It's an act to amend Section 6703, 6802, and 6805, all of Chapter 6, Title 11, Guam Code Annotated, relative to payment requirements for cigarette tax stamps.
Senator, could you just repeat, is that as amended by the committee?
Yes, as amended.
All right. On the motion to place Bill number 104-36 as amended by the committee onto the session agenda, is there any objection? Hearing no objection, motion carries. Senator Torres, you are recognized.
Thank you, Madam Speaker. I move to place Bill number 87-36 COR as amended by the Committee on Education, Self-Determination and Historic Preservation, Infrastructure, Border Safety, Federal and Foreign Affairs, and Maritime Transportation, which was introduced by myself, Senators Nelson, Munya Barnes, into this session agenda. This is an act to add a new Article 4 to Chapter 73, Division 7, Title 5, Guam Code Annotated, and to amend Section 6603C, Article 6, Chapter 6, Title 11, Guam Code Annotated, and to further repeal Section 6604, Article 6, Chapter 6, Title 11, Guam Code Annotated, relative to authorizing asset forfeiture for the Guam Customs and Quarantine Agency, and to further establishing a customs local forfeiture account.
On the motion to place Bill number 87-36 as amended by the committee onto the second reading, is there any objection? Seeing no objection, motion carries. Are there any other motions? There being no other motions, we are now on the second reading, and we will recess until 2 p.m. today. Sedilus Masi.